PES University, Dr. K.S. Sridhar, respected Registrar of PES University, all the other deans, dignitaries, directors, and faculty members. Namaste and welcome once again to Juris Conscientia Law Summit 2023, organized by the Faculty of Law, PES University, Bangalore. In the morning session, we had the privilege to host Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court of India, who spoke to us on public interest litigation, boon or bane for good governance. We also had the presence of our respected Chancellor, Professor Dr. M.R. Doraiswamy sir, our Pro-Chancellor, our Registrar, and all the other dignitaries. This session, we are indeed honored and privileged to have amongst us Honorable Mr. Justice Srinivas Harish Kumar, Judge of the High Court of Karnataka, who has kindly consented to deliver an address on shaping 21st century lawyer and contemporary challenges. Before we start our function, let us have a short film on PES group of institutions. I request my technical team to kindly relay the short film on PES. PES University is one of the country's leading teaching and research universities and is committed to providing navigation for the real world that inspires students to find their true north. And this is the 50th, the golden jubilee year of the institutions started off as PES. The Faculty of Law in PES University was established in the year 2017 under the able patronage and guidance of Professor Dr. M.R. Doraiswamy sir, the Chancellor of PES University, and it offers 5 years integrated law programs across 10 semesters. Let us now have a look on the short film on the Faculty of Law.
PES group of institutions became the university, PES University in the year 2014, and we started our law school in the year 2017. Our law school is 6 years old now, where one batch is graduated. We have 2 programs, BA LLB as well as BB LLB. The students of law school are oriented in a way which we call here as agile. The entire curriculum which we have built in School of Law is based on the fundamental thought process of the service to the society, and we also have the fundamental thought process of building the ethical advocates for the nation building tomorrow. And we make a combination of the subjects in such a way that they will be strong conceptually and also they're strong contextually. The future for all our law graduates is into the litigation or into the corporate. And we really would like to see our alumni in one of the prominent positions in next 5 years to 10 years on the other side. The law school also has a great ambition, great vision of being in top 10 in the nation in next 3 years or so, and my entire team is working towards making this vision a realization in the future as such. So I'm sure with all these efforts we'll be in the top 10 in next 3 to 4 years or so. Thank you so much.
Thank you. May I now request Dr. Shailashri Haridas, Advisor Faculty of Law, and Dr. Sujit P. Surendran, Associate Dean Faculty of Law, PES University, to escort our chief guest, Honorable Mr. Justice Srinivas Harish Kumar, and Professor D. Jawahar, Honorable Pro-Chancellor, and Dr. K. Sridhar, Registrar, PES University, onto the dais. With a huge round of applause, let us welcome all the dignitaries on the dais. May I now request all to rise for the national song, Vande Mataram.
Vande Mataram, Vande Mataram, Sujalam Sukhalam, Malayaj Sheetalam, Sasya Shyamalam Mataram, Vande Mataram, Shubhrajyotsna Pulakitayamini, Pullakusumita Drumadala Shobhini, Suhasini Sumadhura Bhashini, Sukhadam Varadam Mataram, Vande Mataram, Vande Mataram.
Thank you. May I now invite our pillar of strength at PES, a committed teacher, an able administrator, and a warm host, Dr. K. Sridhar, the respected registrar of PES University, to welcome the gathering.
A very good afternoon to one and all present here, and a very warm welcome to the Law Summit for the second part during the day. We have amidst us in this session Justice Srinivas Harish Kumar. Honorable Justice Srinivas Harish Kumar, who is known for vigorously advocating the efficient and effective administration of justice, was born in the year 1963. In the year 1987, his lordship was enrolled as an advocate and has carried out its independent practice at the High Court of Karnataka, situated at Bangalore, as well as in the Chikballapur City Civil Court. In the year 2002, his lordship was directly appointed as the district and sessions judge. His lordship also served as the additional district and sessions judge at Tumkuru and City Civil Court at Bangalore, as the districts and sessions judge at Bidar, Chitradurga, Bangalore rural districts. Additionally, Bangalore's Karnataka Judicial Academy was directed by the distinguished Honorable Justice Srinivas Harish Kumar. In the year 2016, his lordship was appointed as an additional judge of the High Court of Karnataka and as the permanent judge of the High Court of Karnataka during the year 2018. His lordship is commended for his sensitivity to judicial proceedings by several luminaries. His lordship on various occasions has advocated the need for amendments and legislations to enable the courts to conduct their operation in a better manner. In lieu of the same, his lordship had stated, justice suffers if the judges blindly place reliance on case law without understanding the true purport of the principles laid down in these decisions, without disregard for the first principles of law. In another instance, his lordship is known to have recognized the loopholes that exist in the inaction of the police and has established that the failure to take action must be submitted by a report. These orders passed by his lordship propagates his dynamic and versatile knowledge of justice and law. It's indeed our good fortune and pleasure to have a person of his eminence, Justice Srinivas Harish Kumar, the High Court Judge, amidst our presence this afternoon. I, on behalf of PES University and behalf of all of us present here, extend a very warm welcome to Justice Srinivas Harish Kumar. If Justice Srinivas Harish Kumar is a legal luminary, we have another luminary on PES campus, and that is Professor D. Jawahar. Professor Jawahar completed his MS in Mechanical Engineering from the Texas A&M at the United States of America. And prior to that, he obtained his bachelor's degree in engineering from the Bangalore University. Ever since his return to India in the year 1991 and joining PES, he has been consistently striving to attain quality in all quarters at the PES institutions. He is well known for an advocate for total quality education initiatives and spirit, and currently agile for continued growth, and is a proponent of technology in teaching, learning, assessment, and governance. During the year 1991, for the first time ever heard of in the academic circles, Professor Jawahar implemented the campus-wide quality improvement program, which led to PES to a very new destination altogether, and we are all enjoying the fruits of the implementation during that year by Professor Jawahar. For more than 3 decades, he has ensured the development of PES institutions, overseen a significant rise in student diversity, expanded PES activities in teaching, learning, and spearheaded the PES group through strategic planning exercises designed to improve its academic models. Professor Jawahar and his dedicated team at PES have demonstrated the core values of PES, namely perseverance, excellence, and service in all their endeavors. It's indeed our pleasure to be working under him, interacting with him, and knowing from him. Professor Jawahar is energy, and energy is Professor Jawahar, and he strives for quality in all aspects of education. It's indeed my pleasure to extend a very warm welcome to Professor Jawahar for this occasion this afternoon. A graduate from IIM Calcutta, Dr. Shailashri Haridas joined PES group of institutions a little over 2 years ago, and she is the Dean of the Faculty of Management and Commerce. Ever since she took over as the Dean, she has been striving hard to enable student activities in these departments and has proved her mettle by arranging meaningful activities such as this. It's indeed my pleasure to extend a warm welcome to Dr. Shailashri Haridas. Also present on the dais is Professor Sujit Surendran, the Associate Dean of the Department of Law. A very warm welcome to you, Professor Sujit, from all of us here. I take this opportunity to extend a warm welcome. Please. I take this opportunity to extend a warm welcome to the deans and chairpersons of various programs of study of PES University. I also take this opportunity to extend a warm welcome to all the students who are present here. I think it has been an excellent day for all the students as part of our learning atmosphere out here. I also take this opportunity to extend my warm welcome to the members of the press and the media who have been ever encouraging and giving us wide publicity in terms of the activities that happen on the campuses of PES. I also extend a warm welcome to all the faculty colleagues of mine who are present here for this occasion. Finally, I extend a warm welcome to one and all present here. Thank you.
Thank you so much, sir, for that warm welcome. On behalf of PES Group of Institutions and also on behalf of Faculty of Law, we would like to extend a very warm welcome to Dr. K.S. Sridhar, our Honorable Registrar of PES University. Thank you so much, sir. For more than 3 decades, Professor D. Jawahar has ensured the development of PES institutions, overseen a significant rise in student diversity, expanded PES activities in teaching, learning, and spearheaded PES Group through strategic planning exercises. A passionate administrator, a visionary, an inspiring leader who believes in action rather than words. It is our pleasure to extend a very warm welcome and to invite Professor D. Jawahar, Honorable Pro-Chancellor of PES University and CEO of PES Group of Institutions, to address the gathering.
distinguished dignitaries on the dais, faculty colleagues, and my dear students. At the outset, it's my pleasure to address you all this afternoon. This is for me a very significant day in terms of history of how to build a good program. The fact that we are celebrating 50 years of PES and we are having an activity of this order today actually gives me a lot of confidence in terms of where we are headed as an organization. Today morning, every talk that I hear, I learn a lot from whatever happens in these activities. So for me, in the sense that it's gainful experience, and quite often I request that after an event is over, just send me a small video clip. I want to see what the speaker had to say, even if I'm not a part of those events. I remember what her ladyship, Nagratna, said in the morning when she said, a lawyer should think about three things. One is the mind, the heart, and the pulse, okay? I felt that was a big takeaway for me. It's not only, it's such a very significant thing that she said. It had a very deep impact, which is probably true of any human being. Whenever you have to take any decision, it doesn't matter whether you're a lawyer or not, your mind has to start working. Your mind will start working only in case you have abundance of knowledge and then wisdom of implementing that knowledge in any form or pattern. And then in the sense that you need to have a heart in this mechanism. It's not just going to be saying that this is a book and you throw the rule book and say this is how we're going to be doing stuff. And saying that there should be a heart to understand the context. And the context comes from the pulse. So we need to understand our society and where are we giving these particular judgments. So I felt that that was something very relevant to what we need to do. PES was always known to be a good engineering school, and that's where the entire journey started. When you look at how the flagship program of the PES University is working, you try to emulate the best practices of the flagship program in all other programs. The natural extension of an engineering school was the management school, because if students had to graduate and if they're not looking at engineering as a master's level, you need to do a management school. That was fine. When we became a university, we could just not be one engineering school and one management school claiming to be a university. And that's when the diversification started happening. The logical extension for engineering was architecture. The logical extension for architecture was design. And one of the courses that we wanted wherein students from a non-science background could come into an program was the law program that we started in 2017. Whenever we start a program in PES, I always talk about the older journey that we had. In 1991, I was just sharing with her ladyship in the morning, there were 56 engineering colleges in the state of Karnataka. We were ranked 54. And I felt very happy about that position because you can't go any lower from there, okay? You're already at 54. How bad can you be? The only way you can improve is the program. And when somebody talks about the law school today, where is the PES law school? I'm not really worried about the position that we are in today. But I can promise you this. In the next 5 years, PES law school is going to be ranked amongst the top 10 programs in India. That's my promise to you. Whatever it takes, whatever effort has got to be put, all those things are going to be put. Traditionally, whenever we started a program, we had a lot of obstacles. One, there were no resources. Financial resources was a problem. Infrastructure was a problem. Faculty was a problem. Getting good students were a problem. So when I look at all these things that are there, PES has kind of overcome the first two problems. We are no longer worried about finances. We are not worried about infra. We are looking at the next two aspects that is there. How do we get into our roles passionate faculty members who can make a tremendous impact on our student body? And next is how do we get the best of the class students to be a part of the program? And that's where our new agile strategy has been put in place. And we strongly believe that whatever thoughts that we have internally in terms of what we need to do, if we effectively implement the plan that we have in mind, I'm sure that good things are going to be happening. With these few thoughts, the morning's program was excellent. I'm more excited about the topic of interest for what our chief guest is going to be addressing today, Shaping the 21st Century Lawyer and Contemporary Challenges. Wonderful topic, very, very curious. Because one of the things that I said is for a lawyer to be very productive, you probably need to look at the other facets of what law is getting into. One thing that we looked at is the business school that we have right now. It's called as the melting pot. Every law school student who's going to be coming out of PES University should do a few courses in the business school. That becomes very important for us. The second thing that we are looking at it is every law student should be a better communicator by the time you're going to be graduating from the portals of PES. That's also very important to us. Using the technology that is available within the campus, we need to see whether we can kind of give you tools by which you can make better lawyers, data sciences, data analytics, artificial intelligence, machine learning. I don't know if some of you have dabbled with ChatGPT to say, if there is a case law that is going to be there, can you list all the cases historically in India and the judgments that has been passed on by giving a command? Has anybody tried it? So the question that comes in is that there is a very creative way in which law can progress. If you're going to be looking at solutions within the box, I think we're going to be constrained by the way we think about solutions. But if you're going to be looking at solutions outside the box, I strongly believe there are wonderful opportunities, and there's a place that we can make for ourselves as PES Law Program. With these few remarks, I thank His Lordship Justice Srinivas Harish Kumar for having made it to this afternoon's function. I'm sure he had a tight schedule. Making time for an activity like this was very difficult, and he has made it here. Thank you very much, sir. We look forward to hearing from you. Thank you and wish you all the very best.
Thank you, sir, for those inspiring words. I'm sure we at Faculty of Law will live up to your expectations. We feel indeed honored and privileged to have amongst us a legal luminary, Honorable Mr. Justice Srinivas Harish Kumar, Judge, High Court of Karnataka, who from his busy schedule has agreed to grace this function with his presence. Before inviting our guest of honor for the address, let us have a look at a short film on the life and work of Honorable Mr. Justice Srinivas Harish Kumar.
Honorable Justice Srinivas Harish Kumar, who is known for vigorously advocating the efficient and effective administration of justice, was born on 16th June 1963. In the year 1987, his lordship got enrolled as an advocate and has carried out his independent practice at the Chikbalapur City Civil Court as well as in the High Court of Karnataka. In the year 2002, his lordship was directly appointed as a district and sessions judge. His lordship served as the additional district and sessions judge at Tumkuru and City Civil Court at Bengaluru. His lordship also served as a principal district and sessions judge at Bidar, Chitradurga, Bengaluru rural districts. Additionally, Bengaluru's Karnataka Judicial Academy was directed by the distinguished Honorable Justice Srinivas Harish Kumar. In the year 2016, his lordship was appointed as an additional judge of the High Court of Karnataka and as the permanent judge of the High Court of Karnataka in the year 2018. His lordship is commended for his sensitivity to judicial proceedings by several luminaries. His lordship, on various occasions, has advocated the need for amendments in legislations to enable the courts to conduct their operation in a better manner. In lieu of the same, his lordship has stated, justice suffers if the judges blindly place reliance on case law, without understanding the true purport of the principles laid down in those decisions without disregard for the first principles of law. On yet another occasion, his lordship's concern towards the society at large and youth in particular was echoed in a case wherein a drug addict had sought bail. His lordship's verdict in the said case is an eye-opener. In another instance, his lordship is known to have recognized the loopholes that exist in the inaction of the police and has established that the failure to take action must be submitted by a report. These orders passed by his lordship propagates his dynamic and versatile knowledge of justice and law. We are immensely honored to welcome Honorable Mr. Justice Srinivas Harish Kumar to Juris Conscientia.
With a huge round of applause, let us welcome our learned guest of honor, Honorable Mr. Justice Srinivas Harish Kumar, Judge, High Court of Karnataka, to speak on the topic, Shaping 21st Century Lawyer and Contemporary Challenges.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. Professor D. Jawahar, Pro-Chancellor of PES University, Dr. Shailashri Haridas, Dean Management and Commerce Advisor, Faculty of Law, Dr. K.S. Sridhar, Registrar, PES University, Dr. J. Surya Prasad, Vice Chancellor, the teaching faculty, my dear students. Really, I deem it a great privilege to be here amongst the students of law and the teaching faculty of this great institution. Because of my immense passion towards teaching, I love to be among students. I was the director of Karnataka Judicial Academy for about 2.5 years, where I used to teach law to the newly recruited judges. We were training the judges who were recruited to the posts of civil judges, junior division, and also the district judges, directly recruited district judges. Therefore, I readily accepted to come out to this college, even though today is a working day. Thank you for extending invitation. I was asked to speak on a subject which would benefit the students. I was asked to choose a subject. Therefore, I thought it that I should speak on a subject which would shape the career of students. I believe that most of the students who are gathered here may take up legal profession. If our aim is to become a lawyer, eyesight is good. For the society today needs good lawyers. When I use the word lawyer, you may think that the word lawyer refers to advocates. I have not used that word in that sense. Lawyer means, in the ordinary sense, it may be correct. Lawyer means an advocate, it may be correct. In my opinion, lawyer means an advocate or a judge or who fights for the cause of justice. There lies a subtle distinction in using the word lawyer. A lawyer is one who is aware of law, conscious of law, and cares for its implementation in the interest of society and in the interest of the sufferers. These qualities must essentially be present in an advocate and a judge. Otherwise, one does not become a good lawyer or a judge. Our country has seen great advocates. To name a few, M.C. Settleward, who was the first Attorney General of India from 1950 till 1964, I believe. K. Munshi, Feroz Shah Mehta, Badruddin Tabji, and Nani Palkhiwala, whom I have seen and heard his lectures on the budget. Every year he used to come to Bangalore and deliver lecture on the budget in the month of April. I think I have attended 3 such speeches delivered by Nani Palkhiwala. And among judges, Justice Gajendra Gadkar, Justice Vivian Bose, Justice Hidayatullah, Justice P.N. Bhagavati, Justice E.S. Venkatramaya, Justice M.N. Venkatachalaya, before whom I appeared on the first day of my enrollment. It was a great pleasure to appear in his court. Then Justice Krishna Iyer, whose judgments you can't understand without a dictionary. And then Justice Ravindran, who is still among us, and I have practiced before him as a lawyer. So these are all the few names of great judges we have seen. With this prelude, now I come to the topic. There must be 3 essential qualities for a lawyer. These qualities apply for all the ages to come, all time to come. Not necessary for a 21st lawyer, a century lawyer. They are literary habit of mind. Number 2, scientific habit of mind. Number 3, legal habit of mind. These are the 3 qualities that a lawyer, an advocate, or a judge must essentially possess. First, I take up literary habit of mind. What is literary habit of mind? All of you know that language is a powerful weapon. The language of advocates of the yesteryears was supposed to be of a high standard. Not present. If you come to court, you will come to know how badly the language is being used. A judge is judged by his judgments and his behavior in the court and with the public. Howsoever intelligent a judge may be, if he writes a judgment in a language difficult to understand, there is no use. Therefore, the language to be used must be simple. Judgment must be indicative of good comprehension of facts, analysis of evidence, and reasons for drawing conclusions. There is a shloka in Narada Smriti, how a judgment should be. Shloka is like this: Sakalam Purva Padancha Sottaram Sakriyan Thatha Savadharanam Chaiva Tadnyeya Jayapatrakam. I give the meaning. Jayapatraka means, in Sanskrit, judgment. What a judgment should contain. Jayapatra, judgment, Tirpu. Sakalam, everything of what? Everything of Purvapada. Purvapada means the plaint. A plaintiff, a suit commences with presentation of plaint, you read in Civil Procedure Code. Everything of plaint, gist of plaint. Sa uttaram. Uttara means reply to the plaint. That's written statement. So, judgment must contain gist of plaint and written statement. That's what we called marshalling of facts. Then, sakriyam. Sakriyam here in this context means evidence. What the plaintiff produces in support of his case, the defendant produces in support of his case. Sakriyam, analysis of evidence. And savadharanam means how you analyze, how a judge analyzes the facts, the evidence, constitute the reasoning portion of the judgment. If all these elements are present, it's a good judgment. So the judgment to be effective, language must be effectively employed, or otherwise one cannot understand a judgment and it cannot be called a judgment at all. So far as an advocate is concerned, he has got a greater role to play here, because when a client comes to his office and tells all his problems, the advocate must be able to grasp what actually the problem he has faced, where lies the injustice. So what is the relief to be claimed? Understanding, taking instructions from the client, then he must draft a plaint. Then, after presentation of the plaint, defendant appears before the court. I believe all of you are aware of these proceedings in the court. Reply must be given to the plaint. That is called written statement, Order 8 Rule 1 CPC. Therefore, after presentation of plaint and after filing of written statement, the actual hearing commences in the court. So advocate is supposed to present his case before the court. It is in this context, literary habit of mind plays an important role. Literary habit of mind means, it doesn't mean that everybody should be a Shakespeare or Wordsworth or Kalidasa or Kuvempu. No, not like that. True test of literary power is careful choice of words, controlled movement of the thought in every sentence and every phrase towards purpose in view. In other words, knowing the purpose and using discrimination of what should be expressed and what should not be expressed. When I was practicing an advocate, I was introduced to a very senior advocate. By that time, his age was more than 90 years. Still, he was very active. He wanted me to prefer an appeal to Karnataka Appellate Tribunal in connection with a revenue matter under Land Revenue Act. He asked me to draft the memorandum of appeal. He wanted to test my drafting skill because he had passed BA in English literature somewhere in 1920s. he had a great command over English language. Being influenced by this Bangalore style of pleadings, as usual, I wrote the appeal memo in 10 pages, 10 or 15 pages. He read it. He said, "No, I am not happy. Can you reduce it?" "Yes, sir." I redrafted it, showed him the second draft. Still, he was not happy. Then I gave him the third draft, running for only 3 pages. He approved it. This is the precision he wanted. That means expressing everything in limited words. That is the literary habit of mind. Know all, precisely put, know all that you can, but say only what is strictly to the purpose. I am hearing an argument in an arbitration case. The appeal memo runs about 100 pages. I know that I can't dictate judgment in the open court because of the complex nature of the dispute. But if I start reading that petition, by the time I go to the 100 pages, I have forgotten the first or second page. They have narrated everything which is not at all necessary, no use at all. This is not required at all. Therefore, when you read the subject, drafting, pleading, and conveyancing, the art of precision is taught. This is most essential. Unless you have a good command over the language and know what is to be stated and what is not to be stated, you don't make yourself a good advocate. Literary habit of mind helps you acquire all these qualities. Next one is scientific habit of mind. You know, a scientist goes behind truth and the whole truth. This is a strong point. He believes in none except specialists and experts. He doubts everything until his ideal of exact knowledge is realized. This is the quality of a scientist. A lawyer need not be a scientist, but he must have a scientific temperament. This temperament comes in handy to understand the case before him. It is enough if he starts thinking logically with little bit of scientific temperament. It is in this context we study medical jurisprudence, toxicology, anatomy. A judge must know the anatomy. An advocate must know anatomy, because when you decide the cases for compensation in relation to road traffic accidents, the injured will come before the court for compensation. He says, this is the injury I have suffered. On account of this injury, I am not able to work. My earning has come down. This is a percentage of disability. So grant me compensation in proportion to the bodily disability. He brings a doctor to speak about the disability. With great respect to the doctors, there are some professional witnesses among the doctors who routinely come to court. In all cases, they are the witnesses. Even though there is 10% disability, they take it 60%, 70%. Only intention is to grab more compensation. Now, if you have a little bit of knowledge of anatomy, the moment you see the wound certificate and come to know what is a disability, where is a fracture? Okay, if there is a fracture to hand, so there is an amputation up to this point. If the injured he was a driver by profession, he can't drive. So there is 100% disability. That's good. But a businessman suffers a fracture. For about 2 or 3 months, he becomes disabled. Afterwards, he can do the business. But what he does, because of fracture of my right hand or left hand, I can't do business. Is it believable? Students sitting, you easily understood the concept. That means this kind of a knowledge of anatomy helps you decide the cases. This is what is scientific temperament. Therefore, this scientific thinking always helps take decisions properly in all the cases, whether it is civil or criminal. In criminal cases, if a case is based on circumstantial evidence where there is no direct proof for the, say, a case of murder, there is no direct proof. Everything is based on circumstantial evidence. So many circumstances are to be proved. The time of death is disputed. So what we go by post-mortem report is the abdomen, when it's dissected, if it contains partially digested food, it helps approximately to fix the time of death. So the food particles require 3 or 4 hours to digest. Partially the semi-digested food particles are present inside the stomach means the incident might have occurred probably 2 hours after taking the last meal. Therefore, these are all the aspects which essentially an advocate must know, and also a judge. This is a scientific habit of mind. Then, legal habit of mind, the most important. I explain you with this an instance. You know Abraham Lincoln? He was an advocate before he became the President of the United States of America. He had a very good practice. He constantly came across the word demonstrate. Everybody know, all of you know the meaning of the word demonstrate. He first thought that he knew the meaning of the word demonstrate. But soon he realized that he did not know the meaning of the word demonstrate. So he consulted Webster's dictionary. It gave him the meaning, proof beyond probability of doubt. This is the meaning he saw from the dictionary of the word demonstrate. He was not happy with this meaning. he said to himself, Lincoln, you never make a lawyer if you do not know what demonstrate means. And therefore, he worked on the meaning of the word demonstrate, burning midnight oil after hard days of work in the courts. I have taken this instance just to explain the meaning of the word legal habit of mind. Legal habit of mind is a combination of scientific habit and literary habit. In the instance of Lincoln, he went behind the meaning of the word demonstrate, that he shows his literary pursuit, and he was not happy with the meaning he got from the dictionary. He tried to understand the meaning of the word demonstrate from the legal perspective. So that means he had a temperament, scientific temperament, to understand the meaning of that word. It's a combination of both literary habit of mind and scientific habit of mind. Therefore, legal habit of mind means habit of analysis and abstraction. Truth is and must be the lawyer's object, and in search of it, he must get rid of all preconceptions, prejudices, because any prejudice I have is not a proof. My suspicion does not take the place of a proof. That is the established principle of law. Any amount of doubt does not take the place of proof, legal proof. Therefore, if the students or an advocate or a judge wants to develop the legal habit of mind, one must frame a theory first. Say in mathematics, you take an equation. There is an unknown, x plus 1 equals 0. So what is the value of x? This is how the theories are built up. So in the legal field also, you have an outline of a problem before you. Think of it from all possible angles. And ultimately, come to some conclusion which must appear to be acceptable, convincing. That is called preponderance of probability. So the lawyer's business must be to find out truth with the available legal evidence. And here, common sense plays an important role. Common sense means we must refer to Indian Evidence Act, drafted by James Fitzgerald Stephen. James Stephen. He has written a book, Indian Evidence Act, with an introduction on principles of judicial evidence. I request all the students to read it. After drafting the Indian Evidence Act, he wrote a book on the Indian Evidence Act, from what angle, what was his thought process before drafting, everything you see in that book. There you find a theory called agreement and disagreement. You agree with something, disagree with something to draw conclusions. This is called legal habit of mind. But unfortunately, today, Evidence Act is neglected. In schools, in law schools, I don't think Evidence Act is being taught effectively. read a section, feed a case law, enough. That is not the way of teaching Evidence Act. For example, Section 3 defines what a fact is. What is a fact? Any student here can give the definition, legal definition? Anything capable of perception. Indriyartha sannikarsha jnana, what is called Indriyartha sannikarsha jnana. Indriya means what? 5 senses. Everything perceptible to 5 senses is a fact. I am standing and speaking here, it's a fact. You are listening to me, it is a fact. I touch this table, is a fact, because my skin perceives. So this is called fact. Give an example, lively example, students will easily understand it. Evidence Act says, hearsay evidence is not acceptable. What is the concept of hearsay evidence? Why? You read some case law, write examination, it's over. But practical demonstration? I call 10 students here, write something on a slip, paper. I call the first student, read it. I take back that slip. Ask him to pass on that information to the second student, so on up to the 10th one, last one. Then I ask that last student to say what you have been, what your, the information passed on to you from the 9th student. What I have written is something different from what he says. That means information passes from one person to another, changes. Therefore, the hearsay evidence is excluded. Direct evidence is always preferred, because whatever one hears from others, when he comes to court and reproduces the same, it will not be the truth. That is the reason why hearsay evidence is excluded. I don't think that this concept is explained in the classrooms. A lively demonstration is necessary whenever Evidence Act is taught. Evidence Act, I said, is a codified common sense. Probably under the impression that everybody's common sense is good. Nobody studies Evidence Act. That is not the correct way of understanding. Yes, it is a common sense, but common sense of many people of many ages. Combined experience of many people, of wise people of many ages, is the common sense, what we see in the Evidence Act. So this is the way how legal habit of mind makes you help the legal concepts. So with this, 3 essentials to be present in a student, one who wants to become a lawyer or a judge. I want to say something more. Whatever be the opinion of the public towards a lawyer, lawyers are blamed. They are the extract money. They become rich at the cost of others. These are the blames. But society cannot live without lawyers. So lawyers, good lawyers, are very much needed. You know why a lawyer easily becomes a leader of the society? I read an article written by Satyamurthy, who was the General Secretary of Indian National Congress during freedom struggle time. He was a great lawyer of Madras. He writes, lawyers do come in contact with teachers, doctors, engineers, businessmen, everybody. So in the process of giving solutions to their problems, maybe professional or their individual problems, he understands the society very well, better than others. So naturally he grows himself to be the leaders of society. Therefore we have seen great lawyers, Bal Gangadhar Tilak, Jawaharlal Nehru. They were all leaders of the society. They were all leaders during our freedom struggle time. Even Mahatma Gandhi was a lawyer. Though he did not succeed as a lawyer in India, he went to South Africa and flourished there. He fought for the cause of the Negroes, the black, and came back to India and fought for the independence of our country. So this is what we read from history. Therefore, lawyers, the students who want to become lawyers have got a greater opportunity to become the leaders of the society. And today, coming to the 21st century lawyer, we don't find that traditional litigation now. Earlier, only civil and criminal. Civil branch is to be a difficult one, is considered to be a difficult one when compared to criminal. Because one who knows civil law can easily handle a criminal matter, but converse is not true. One who specializes in criminal law cannot handle a civil matter like that. That kind of traditional litigation we don't find now. Modern day lawyering has changed. So lawyers have to face new challenges. So thinking and working needs assistance from modern tools. There is a phenomenal change in the pattern of the litigations. Globalization, technological advancements have been, they were not earlier, but now you come and sit in the court, you will come to know what kind of cases come before the court nowadays. Really challenging. So internet-related crimes are increasing. Artificial intelligence has found a new dimension. So unless a modern lawyer is equipped with technology, he cannot meet the challenges. Therefore, to shape yourself as a good lawyer for the century, in addition to having all the three qualities, what I just stated, you must be equipped with modern changes. The changes contemporary, you must know the contemporary issues, must get in touch with the technology, make use of technology, and work hard. You must work hard. Unless you are ready to work hard, you can't become a good advocate. When I joined the profession in the year 1987, my senior said, "How much money you expect from me?" I said, "I don't want money, I want work. I want to learn the work." He told me, supposing that an advocate practices for 30 years, you divide 30 years into 3 parts. First 10 years, all work, no money. Second 10 years, some work, some money. The last, all money, no work. That means, in the initial stages, if you go behind money, you don't learn work. If you want to become a good advocate, you must do a lot of sacrifice. And one important advice that you want to give is, after finishing your law course and getting enrollment, don't practice in High Court or Supreme Court. Build your career in the trial courts. First 5 years, forget High Court. If you directly come to High Court, you don't learn anything. Because the foundation is in the trial courts. You can't construct a house or a building without foundation. Foundation is in the trial court. Trial court is the place where legal occurrence is exhibited. Therefore, with these words, hope I have not taken your much time. My lecture was not boring. Conclude. Thank you all. ಇಲ್ಲ.
With the permission of Honorable Mr. Justice Srinivas Harish Kumar, we would like to take a few question answers. First question, please. Yes. Your Lordship over there.
Greetings to Honorable Justice Srinivas Harish Kumar, sir. I am Pragati from third year. Your Lordship, in our classes we learn that morality should be kept away from legality while deciding or analyzing cases.
Yes.
In practice, are judgments immune to morality, or does the inherent morality of judges play a role in the judgments? Thank you, Your Lordship.
Good question. But we were not taught, when we were students, we were not that morality must be kept aside. I don't think this is a new concept nowadays. What is law? It's based on dharma. It's a moral concept only. So why do you think of implementing law without moral principles? All that I want to say is, when I sit, now I am a judge, all my prejudices, all my notions should not influence my decision-making process. I may be having some notions. That should not influence me. I must decide the case impartially based on the facts and the evidence. Dharma, the concept of dharma, is the law, according to me. What is dharma? Dharma is right conduct. What is good to the society? If somebody does anything contrary to dharma, it is an offense. If moral principles are kept aside, I don't think it makes a good law. Indian Penal Code, what does it say? Crime is not defined, but you say there are a number of sections dealing with punishments, defines the crimes. Why is it punished? Because it is against society. When it is against society, it is based on moral principles. Theft, that is defined in Indian Penal Code. One should not steal. Again, it's a moral concept. I don't understand why these moral concepts are, the nowadays trend is like that. I really don't understand. See, there is one sloka, Dharma Shastraanusarena Krodha Lobha Vivarjitaha. That means what? It's a directive to the judge. When you decide a case, you must decide the case without having any kind of notions, prejudices, and without being enticed by avarice, that's durase. You decide a case like this, that is what is expected. The moral conviction, you mean to say, that is not permitted. I must see the evidence before me, decide the case, whether there is evidence for convicting a person. I take an instance. When I was additional session judge at Tumkur, a case of 302 was tried before me, murder. the witnesses, the deceased, that means the person who was killed was the wife of the accused. Husband killed the wife, in simple words. All witnesses turned hostile. All witnesses. Who were the witnesses? Father of the accused, mother of the accused, grandfather, grandmother, they were the prime witnesses. Obviously, they turned hostile. They don't want their son or grandson to be convicted and punished. All turned hostile. Yet I convicted him for 302. Based on what? Applying section 106 of the Indian Evidence Act. What does it say? If I know something, I must disclose it. If it is not within the knowledge of anybody, I only know what. See, the facts were like this in that case. The husband and wife, there were some differences that apart. The wife was quite healthy till she went inside the bedroom. She had her food, dinner, so went to sleep. She was quite healthy. Next day morning, she was found dead. There was a mark, a ligature mark here, case of strangulation. The incident occurred inside a bedroom where the husband and wife were there. So when she was found to be killed and there was a ligature mark on the neck, who should explain it? Husband alone. So notwithstanding hostility of all the witnesses, a clear case of conviction. No question of morality there. So this is how we decide the cases.
Thank you. Thank you, Your Lordship. Can we have the next question, please?
Greetings to Honorable Justice Srinivas Harish Kumar, sir. Lordship, which has been the most challenging case that your Lordship has dealt with till date?
Every case is challenging in that way. Whether it is a simple suit for recovery of money based on a pronote, or a suit based on a contract for specific performance, or everything is challenging. The question is, it's not challenging, it's not difficult. No, I have not found any case difficult. I think that I am quite competent to handle any difficult case. Challenging in the sense, it all depends on how you assess the evidence before you, especially in civil cases, where the theory is preponderance of probability, which is most probable to be accepted. Sometimes the evidence is balanced. Balanced in the sense the plaintiff side evidence and defendant side evidence, both balanced. There we find some difficulty to take a decision. I give one challenging case. It's a very simple case when as an advocate, the bank filed a suit against a borrower for recovering 10,000 rupees, which he had borrowed for buying a two-wheeler. There was one surety for the principal borrower. It was a challenging in this really, because that was tried in my native taluk. I appeared for the surety in that case. The claim was only for 10,000 rupees. My client stood as a surety for the principal borrower. The principal borrower was to repay the loan in installments. I think he repaid it 1 or 2 installments, and then he defaulted. So my client came to know that the principal borrower was not repaying the loan regularly to the bank. So surety, liability is coextensive with that of the principal borrower, as you have studied in the Contract Act. So what he did was, he went to the house of the principal borrower, brought that vehicle, which is hypothecated to the bank, gave it to the possession, custody of the bank, and asked the bank, sell it, realize the dues. But the bank did not, the agreement, loan agreement provided for private sale. But the bank kept it without selling it. For 5 years, the vehicle was in the premises of the bank. When the suit was filed, I took up a defense in the background of, I think, section 141 or 140, I don't remember. Liability of the surety has extinguished because as a surety, he did what he was supposed to do. That means if the principal borrower fails, then the liability passes on to the surety. Now the surety here seized the vehicle, gave it to the custody of the bank, which was supposed to sell it and realize the money. If the vehicle had been sold at that time itself, probably the bank would have realized more than the amount that it claimed in the suit. So this is how I fought. I took up a defense like this. And after a recording of evidence, the suit against the surety was dismissed. The principal, the entire liability was fastened on the principal borrower. It was a little bit challenging because the judge who presided over there at that time did not know all these intricacies. I found it very difficult to convince him. So this is how you must apply law. He said, what is there? Surety stands in the, he steps into the shoes of a principal borrower, you can't escape. That's this ordinary thinking. But when I referred to section 141 or 142, explained, though the subject matter of the suit was 10,000 rupees, but it was really challenging. After becoming a judge, I have found every case very easy. I have not come across such a challenging case in that. Challenging means every case is, I see differently, every case is distinct. I pay equal attention whether it is an easy case or a difficult case based on the facts. That's all I can say.
Thank you, sir.
Thank you, Your Lordship. Can we have the next question, please? Yes, Your Lordship over there.
Greetings to Honorable Justice Srinivas Harish Kumar, sir. I'm Ahdia Zaina from second year. Your Lordship, my question to you is, how can judiciary ensure justice is accessible to remote areas? And what are the reforms that can be done for the same? Thank you.
It's already there. Legal service authorities are constituted everywhere, in every district. It's doing its best to provide justice to all, everybody. You can see the literary camps being held in all the villages. Even in jatras, bus stations, railway stations, nowadays camps are being held to explain the concept of the justice, how they can, what are the rights available to them. That is now being implemented. Nothing new now. Legal Services Authorities is meant for that, is a separate establishment under the Legal Services Authority Act. And I think even in camps are held in this college also. Yes, that is the way access to justice is now provided. Nobody is denied of access to justice.
Thank you. Thank you, Your Lordship. Can we have the next question, please? Next question? Yes.
Greetings to Honorable Justice Harish Kumar, sir. I'm Snehal from second year, and my question to you is, given the urgent need for police reforms in India, what do you see as the most important areas for change in the police force of our country?
Free them from corruption. Our police are really efficient. You have seen good number of cases where they have investigated the cases so fast. But what happens is system is corrupted. Political intervention. If the system is freed from corruption and political intervention, that is the greatest reformation that can be brought. Secondly, these IPS officers and IAS officers, they don't involve, in my experience, speaking from my experience, they don't involve as much as in the investigation process, as much as a police inspector. Directly after they finish their training, directly he is posted as Assistant Superintendent of Police, where their participation in the investigation process is very less. They are really IPS officers, they are really honest, young, energetic, and the system must involve them. So my personal opinion is, a probationer, of course, they are posted as probationary officers where they work as sub-inspectors, police inspectors for a short period. So they don't get that much of experience. So at least for a period of 3 years, an IPS officer must work as a police inspector and must involve in the investigation process. Then only you can expect good investigation. This is my answer. Corruption, free corruption and political intervention is a menace to the police system.
Thank you. Thank you, Your Lordship. Can we have the next question, please? Your Lordship, over there.
Greetings to you, Honorable Justice Srinivas Harish Kumar sir. I am Niranjana from 4th year, and my question to you, Your Lordship, is what are your views on victim rehabilitation, and is there a possibility of it becoming an integral part of criminal justice system?
It is already there. Read section 357A to C. It is already there. It's already there. Question is compensation. It speaks of compensation. Compensation does not mean in terms of money. Law is developing. Any kind of compensation can be awarded. If a person loses property, the accused may be directed to give him property. If a house is demolished, he may be directed to demolish a house. It's already there. It has become an integral part of Criminal Procedure Code. Sections 357A to C. Please read. Earlier there was 357, now it was amended, and these three sections were introduced.
Thank you, Your Lordship. Due to paucity of time, we'll take 2 more questions. 2 more. Yes.
Greetings to Honorable Justice Srinivas Harish Murthy, sir. I'm Nidhi Anand from 3rd year. Your Lordship, Section 376 of the IPC only talks about women when referring to the victim. Have any discussions or conversations been made to make the law more gender neutral?
Can you improve your question?
Yes, sir. Can the law be made more gender neutral? Have there been any...
See, Section 376 IPC speaks about rape.
Yes, sir.
On a woman. Deals with sexual harassment. It can't be made gender neutral. If your doubt is that what happens if the victim is a male, speaking from my experience, in all these POCSO cases, prevention of atrocity on children, it is being misused. Section 498A is being misused. Domestic Violence Act is being misused. In these rape cases, what happens? Most of the cases are low affairs. Because when I was sitting on bail for deciding bail applications, the boy of 16 or 17 years, or a girl of 16 or 17 years, they fall in love, cross their limits. Moment it is noticed, an FIR in the police station, investigation, boy is arrested. For what? Is he at fault? Is the girl not equally, has she not committed wrong? Therefore, if your doubt is whether a male is, the female is to be punished, then IPC requires an amendment. So 370 is, since it deals with a rape on a woman, it cannot be made gender neutral.
Thank you. Thank you, Your Lordship. The last question.
Greetings to Honorable Justice Harish Kumar, sir. My name is Maya, and my question to you is, what is your opinion on the discussion of proposing death by lethal injections as an alternative to death by hanging to uphold the landmark precedents laid down in relation to safeguarding painless and more humane death.
Which judgment has laid down that lethal punishment?
Bachchan Singh's case.
It doesn't say like that, I don't think.
It lays down that it's a more humane and a painless death should be conferred.
I don't think Supreme Court has advocated in favor of injecting.
No, not for lethal injections. That
the Law Commission has recommended, as I know, but it is not yet accepted by the central government. Death by hanging is now considered to be the painless form of hanging, awarding, imposing a punishment. And law has to, amendment has to be brought.
Thank you, Your Lordship.
Thank you. Thank you so much, Your Lordship, for your insightful words and also for patiently answering all the questions.
Thank you.
Let's all give a standing ovation to Honorable Mr. Justice Srinivas Harish Kumar sir for his inspirational words, for a very humble and candid advice to all the budding lawyers here. Thank you once again, Your Lordship. To propose the vote of thanks, may I now invite Dr. Sujit P. Surendran, Associate Dean, Faculty of Law of PES University.
A very good evening to one and all present here. Gratitude is one of the purest and genuine emotions, and expressing that as a culmination of a historic day in PES, I'm honored and humbled by this opportunity. Let me first of all thank Dr. M.R. Doraiswamy sir, the Chairman and Founder Chancellor of PES University, for this opportunity to host Supreme Court Justice B.V. Nagaratna as well as Justice Srinivas Harish Kumar sir on this eventful historic day of PES Faculty of Law. Thank you, sir. Justice Sri Srinivas Harish Kumar sir, it was indeed an insightful session for the budding lawyers of Faculty of Law, PES University. I request Honorable Pro-Chancellor, sir, to kindly hand over a token of gratitude to Honorable Sri Justice Harish Kumar, sir. Thank you, sir. I'm sure, inspired by your words, our students would build the habit of literary, scientific, and legal faculties in their career and in the future. Thank you once again, sir, for enlightening us with a wonderful session. It's my honor and privilege to thank our Honorable Pro-Chancellor, sir, for this wonderful opportunity and encouraging us to conduct events of such magnitude with all support. Thank you, sir. And I also thank Honorable Vice Chancellor, Sri J. Surya Prasad sir, and Ajay sir, the Chief Operating Officer of PES University, for all the support and guidance they have offered in their absence. I also thank our Registrar sir, Sri K. Sridhar sir, for his guidance, support throughout the preparation for the event. And without his constant support and motivation, this event wouldn't have been a possibility. Thank you, sir. Dr. Shaileshri Haridas, Dean, Faculty of Management and Commerce, Advisor, Faculty of Law. Ma'am, it was your immense guidance, support, and constant motivation which has culminated into the grand success of this event. Thank you for your constant guidance, support, and making this event a possibility. Thank you, ma'am. To all, to the deans of other schools, respective deans of other schools and faculty members who joined us today for this event, I extend my sincere gratitude on behalf of Faculty of Law and also the faculty members, students from other departments who joined us today. Thank you, everyone. Thank you so much. The Faculty of Law, my colleagues who tirelessly worked for past 2 weeks for making this event a grand success, tirelessly coordinating with the judges, the administration, the students, the student volunteers, and even various vendors. So the tireless efforts of my faculty colleagues, which is finally we can see the result of this today as in the form of a grand success of today's event. I thank all faculty members for the grand success, for making this event a grand success. Thank you, everyone. All student volunteers, your contribution, each one of you, your contribution to this event is invaluable. Your tireless efforts and motivated and inspired actions have resulted in this event's success. Thank you. I also thank all the parents who came today to attend this event, the media personnel, the police officers, for gracing the occasion today. Thank you. I also thank all the administrative staff of PES University for supporting today's event. I once again thank one and all on behalf of Faculty of Law, PES University. Thank you, everyone.
Thank you, sir. May I now request all of you to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे हे।
Request all the students to stay put till the dignitaries leave the auditorium. As a token of our respect and gratitude, let us give a huge round of applause to the dignitaries who are making their way out after gracing this Juris Conscientia, the Law Summit 2023. Honorable Mr. Justice Srinivas Harish Kumar, Professor D. Jawar, Honorable Pro-Chancellor of PES University, Dr. K.S. Sridhar, Dr. Shailashri Haridas, and all other dignitaries. Thank you. Thank you all. Wish you a wonderful good evening. Law students, please stay back for taking the attendance. Other students can leave.